Can you hear me in the back? Okay, perfect. Well, thank you very much for having me. I want to thank the Baltimore City Historical Society for having me this evening, hosting me, everyone for coming out in the rain, my colleagues from the Monument City Bar Association, and my students for coming. Full disclosure to the audience, I'm not trying to get sympathy points. I actually got out of the hospital last week from pneumonia. I was there for a week. So if it looks like I'm kind of struggling and pacing myself, I'm not going to kill over. I'm just trying to pace my breathing. So just want to let you know about that. But I'm very excited to give this talk. Let me give you a little background about this project first. So this actually started in fall of 2022 when a man named Judge Brown wrote a law review article entitled "To Fight the Battle of First Unity Warriors." And he wrote on the struggle of some of the first black individuals in Maryland who strived to become the first black lawyer in Maryland. And I like to refer to those gentlemen as the first generation. So you heard me say first generation, second generation. I call them the first generation. After that, I actually wrote my own law review article, kind of picking up where he left off on the lawyers that came after the first generation, and how talking about how they passed on the mantle and fought some of the discrimination laws in the late 1800s and late 1800s, early 1900s. So when I say first generation and second generation, that's what I'm talking about. Okay, so let's go on. So my presentation goes to like three. So I want to give you a brief recap on the first generation of African American attorneys, kind of tell you about the legacy. I'm going to start with the first attempts by black individuals to try to become attorneys, and then we're going to go to the Henry Wilson decision of 1885, which is a decision that found the racial restriction in Maryland that barred African American attorneys unconstitutional. Secondly, I'm going to introduce you to the second generation of lawyers and how they used the courts to redress the grievances of African Americans in Maryland in the form of discrimination from private citizens and institutions. Lastly, I'm going to focus on them again, talking about some of their political achievements and also talking about some of their turn of the century attempts to fight anti-suffrage laws and anti-ordinances that resulted in residential segregation and housing in Baltimore City. All right. And then that's the first one, all right? So this is a timeline I put together, and it's important to understand that during the first part of during the 19th century, the thought of a black attorney in any state was really untenable. Until 1832, Maryland didn't really have any set rules about who could become an attorney. It was really up to the various courts to decide the eligibility of attorneys. It wasn't until 1832 that Maryland was one of the first states to create a statute that limited the practice of law to white men. And in my research, I found a source that said this is probably due to the Nat Turner Rebellion, which occurred a year before. And because of that, Maryland and Virginia started passing laws to codify racial discrimination. So, meanwhile, in other parts of the country, especially in New England states, African Americans had some success in becoming lawyers. As a matter of fact, in 1844, Macon Bolden Allen would become the first African American lawyer in the United States. He was licensed in Maine. And then other African Americans would follow suit. Robert Morris in 1847 was admitted to Massachusetts. New York with the admission of George Vashon in 1848, and so on and so forth. So as you can see, Maryland was kind of behind the eight ball in terms of admitting African American attorneys. And it really wouldn't be until 1857 when Edward Draper would make one of the first attempts to join the Maryland bar. So this is Mr. Draper right here. So he grew up in Baltimore, but he went to Philadelphia for his schooling because at the time, the public school system in Baltimore wasn't the best. And he actually graduated from Dartmouth. He was one of the first graduates in 1855. He wanted to become a lawyer with the goal of leaving the United States and going to Liberia. At the time, Maryland had a group of black individuals who actually wanted to leave Maryland and start a colony in Liberia. And so him and his father were big proponents of that. So due to a lack of formal legal requirements, reading the law under another attorney was really the only practical way of becoming a lawyer. And so Mr. Draper spent several months reading at the firm of Charles Gilman, who was a prominent Baltimore lawyer. And then he also witnessed some other attorneys practice law and another prominent lawyer from Boston. And then on October 29th, 1857, he actually took the examination under Baltimore Judge Zacchaeus Lee. So for my Civil War fans in here, I'm sure the name Lee rings a bell. General Robert Lee of the Confederate Army. So Judge Lee was actually his first cousin. He was actually a slave owner as well. So despite that namesake, Judge Lee was impressed by his credentials. He said, you qualified to be a lawyer. There's just one problem. and they happened to me that he was black. And because of that, he was unfortunately unable to join the bar due to that. And I always find it interesting because 1857 is also the year that the Dred Scott case came out. And that was the case in which Chief Justice Taney indicated that African Americans weren't citizens and didn't have the right to citizenship. So I always found it reflective that Draper was denied admission the same year that the Dred Scott case came out. Now, he still had his certificate attesting to his skills as an attorney, and he still intended to use that to go to Liberia to practice law. Unfortunately, while he would make it to Liberia, he would die within a year, so he really didn't get a chance to fulfill his dreams. Now, I want you to remember his name because we're going to come back to him at the end of the presentation because his story hasn't ended, so just keep tight on it. All right? So I want to give you a backdrop about what was going on in Maryland at the time. So around 1860s, when the start of the Civil War, Maryland actually possessed a large population of African Americans. In fact, near the end of the Civil War, half of the African American population in Baltimore and Maryland was actually free. And Baltimore saw a sharp increase in black population between 1860 and 1870. However, despite that, black citizens still couldn't become members of the bar. Now, even though African Americans couldn't join the Maryland bar, the federal court system was a little more welcoming. And so, as a matter of fact, some of the first black lawyers admitted to practice in the Maryland federal court system were already lawyers in other states. And for those who are non-lawyers, if you want to be a lawyer, you have to be licensed under a state. And if you want to practice at the federal level, you have to fulfill some other requirement, like being nominated by someone and taking an oath of office. But it's a little easier to get licensed at the federal level. So, Mr. Wolf. So remember I told you that most black attorneys at this time hailed from mostly the New England states, like Macon Allen in 1844. So some of these lawyers actually ventured south for greater opportunities to practice law. One of them was actually James Wolfe. So he was admitted in the state of Massachusetts, and he actually studied under a prominent Massachusetts congressman. He studied at Harvard Law School, and his goal was to join the Maryland bar and become the first black lawyer in Maryland. Now, he was successful in joining the federal bar in 1875, so he has that distinction, but unfortunately he was barred by that pesky law from becoming the first African-American attorney at the state level. And so I'm hoping that you're seeing a pattern here. You've got Draper and you've got Mr. Wolfe, and unfortunately they can't become an attorney because of that law. And so the only way it seemed that any African-American could become an attorney in Maryland was to challenge that law directly, and that's where we have Charles Taylor. I don't have a picture of him. But Charles Taylor also he was a black lawyer from Massachusetts who also came to Maryland. He was able to join the federal court system, but just like Mr. Wolfe, he was denied joining the bar at the state court system. Now, undeterred, he actually petitioned the Maryland Court of Appeals in 1877 in challenging that law. And the Maryland Court of Appeals is actually the highest court in Maryland. Today it's called the Supreme Court, but back then it was called the Maryland Court of Appeals. And so he challenged law in a case called In Re Taylor. That was the name of the case. And he claimed that under the Privileges and Immunities Clause in the Constitution, admission to the bar was a privilege of state citizenship, and the state legislature could not abridge the right under race. And the Privileges and Immunities Clause in the Constitution basically guarantees equal protection and treatment under the laws of each state. So in other words, you're guaranteed the same treatment under the laws of Maryland as you would be in Massachusetts. And so that was his argument. He indicated the practice law was a privilege, and that privilege as a state citizen should fall under the protections of the Privileges and Immunities Clause. Now, in support of his argument, he cited to the slaughterhouse cases. They occurred in 1873, and this was a few years before his case. And this is really the first time the United States Supreme Court had taken a look at the Privileges and Immunities Clause to define what does that mean. And however, Taylor's biggest problem was that at the time, the Supreme Court really hadn't defined the scope of privileges, and they hadn't really defined what the Privileges and Immunities Clause actually covered. In fact, under the slaughterhouse cases, the one he cited to, the court found that Privileges and Immunities Clause only protected rights tied to U.S. citizenship, not state citizenship. And so if you can remember his argument, that's going to be a problem. So the Maryland Court of Appeals, in his case, kind of agreed with the Supreme Court of the U.S. Supreme Court, indicating that the right to practice law is not a privilege that's covered under that, but rather it's something that's governed by the legislature of each state to set their own rules and procedures. So unfortunately, Mr. Taylor lost that case. Now I'm going to pivot to this lovely lithograph. So this is commemorating the May 1870 celebration of the ratification of the 15th Amendment in Baltimore. So this was attended by a ton of dignitaries, including Frederick Douglass. And at this event, Frederick Douglass famously said, as Black Americans, first we received the cartridge box, then we received the ballot box, now we want the jury box. And so he's alluding to the fact that at this time in 1870, Black citizens couldn't sit in the jury. Now I want you to remember that because that's going to be a very important fact in later cases in which. So despite the celebration still in the 1870s, African Americans were still barred from becoming lawyers. Now, between 1877 and 1885, there were actually numerous challenges to that law by the Maryland legislature himself. There was an attorney named Richard King who petitioned the U.S. Senate and Maryland House of Delegates to overturn that law. Unfortunately, all those attempts were in vain. The next real attempt to overturn that state law came from the Mutual Brotherhood of Liberty. And they were a civil rights organization founded by Reverend Harvey Johnson in 1885. And that's Reverend Harvey Johnson there. And if you do your research, some could argue that the Brotherhood of Liberty is actually a precursor to the Niagara movement of 1905, which in itself was a predecessor of the NAACP. So I'll leave that there for you. But Reverend Johnson joined the fight in breaking down the barrier between Black attorneys in Maryland. And what he did was he convinced a lawyer named Charles Wilson from Massachusetts to come down. And Charles Wilson just came down to teach. He was a lawyer and teaching. But Reverend Johnson convinced him to act as a test plaintiff in the case Henry Wilson. And the goal was to overturn the law, of course. Now, they were represented by a white attorney by the name of Alexander Hobbs. And their argument was that this statute was a violation of the Equal Protection Clause of the Constitution. So you see, they're using a different argument than Taylor used earlier. Now, the interesting crux about their argument is that, let me get my notes right, they actually cited the cases where the Supreme Court had already decided that certain types of discrimination were violations of the Equal Protection Clause. And one of those cases was called Strada. And in the Strada case, the court said that blacks cannot be excluded from the jury. So remember, we're piecing together what Frederick Douglass said back in 1870 for an 1885 decision. And so this is a stroke of genius because this was the same argument that Wilson said. He said if blacks are barred from being jury members, then they can't be barred from serving as lawyers. And the court actually agreed with it. In March of 1885, the Supreme Bench of Baltimore held unanimously that if blacks cannot be discriminated against in jury selection, they cannot be discriminated against the opportunity to practice as judges and lawyers. And so this had the effect of actually overturning the Henry Taylor case. So it sounds like they were doing a good job, but I have a question for you all. By show of hands, did the success of Henry Wilson actually overturn the statute? Who thinks it actually overturned the statute?
Trick question.
No, it didn't. So the reason why is because all the judges said is that despite the term white that existed in the statute, blacks must be allowed to practice law. And remember, this was a Baltimore court, which meant that it only applied to Baltimore. So blacks would still be barred in other parts of the state from practicing law. So my next question, in case you're paying attention, now that Wilson won, did he become the first attorney in Maryland? Now that he won the case? No. For whatever reason, despite winning, the Maryland bar still found ways to disqualify him. I couldn't find why exactly disqualified him, but for some reason he didn't become the first African American attorney. Last question. Do you think Reverend Harvey and the Brotherhood gave up on this? No, not by a long shot. Into Everett Warren. So Everett Warren was a Howard Law graduate, and he was approached by Reverend Johnson to attempt to join the Maryland bar, and it was successful. October of 1885, Warren officially became the first black attorney to be admitted to the Maryland bar. And then a year later, 1886, he'd be joined by his colleague, Joseph Davis. Now, both of them would continue the legacy of the first generation by joining with the Brotherhood of Liberty as co-counsel to fight some of the most egregious affronts to black civil rights. I can't go over everything for the sake of time. One of the first laws that they tried to overturn were called the Bastard Acts. And so this actually gave judges the power to issue warrants against women who bore illegitimate children in an attempt for them to confess to the fathers. And this had a disproportionate impact on women of color, obviously. And so they tried to overturn this law. And even though they were unsuccessful, this was the first time African Americans argued in front of the Supreme Bench of Baltimore. One of their more interesting cases, and I would say this is probably the most fascinating case, is the Nassau case. And so in 1889, a group of laborers from the island of Nassau, this was an unincorporated island in the Caribbean, due to inhumane and cruel treatment, they kind of led an uprising and killed some of their white managers. And because of that, they were charged with first-degree murder that carried a death penalty sentence. And so Warren and Davis represented the group of laborers. And this case actually made it all the way to the Supreme Court. And even though they were unsuccessful in getting an acquittal, this was the first time Maryland lawyers, Warren and Davis, were practicing at the U.S. Supreme Court. So it was still a pretty good deal. And one silver lining that I want to mention is that they were actually able to convince President Benjamin Harrison, to commute the sentences of the clients from death to life without parole. So that's something in itself. So that really ends the first discussion about some of the early, the first generation. Warren would actually later go into a career in real estate. He'd have some bad financial ventures, and unfortunately he would die in 1914 in relative obscurity. Joseph Davis, there wasn't much about him after this, but he would go on to mentor one of the next generation of black lawyers that I'm going to now get into in a segment. So now let's talk about the next generation of black lawyers. I want to talk about two individuals, Harry Cummings and Charles Johnson. There's not much written on Charles Johnson's early life, so I'm going to focus on Harry Cummings for now, and then we'll revisit Charles Johnson. So, love the parents. So, Harry Cummings came from a prominent family. Some of his siblings actually made names of their own. His sister Ida Cummings actually became one of the first Baltimore kindergarten teacher. His parent, he was born in May 19, 1866. His father served as a chef, and his mom was actually in domestic service, and she also worked at missionary work at the church. And both of their parents instilled in all their children the importance of education. So even though Cummings grew up in Baltimore City, he actually had to go to Oxford, Pennsylvania for his high school degree. He went to Lincoln Preparatory School. And after that, he went to Lincoln University, where he graduated in 1886. Let's see. And during his time there, he actually studied under Joseph Davis, the same lawyer who argued with Warren in this case. This is actually a picture of the University of Baltimore Law School in 1889. And so around this time, he would actually meet Charles Johnson around this time. And Charles Johnson actually attended Lincoln as well. And they may have met at Lincoln, I'm not really sure, but for sure they attended the University of Maryland in 1887. And they actually completed the 3-year program in 2 years, so that was very impressive. And before long, they would actually embark on a career vindicating the rights of African American attorneys and the oppressive system at the time. So I found this picture interesting. This is a saloon. This is an 1889 picture of segregated saloons in Baltimore. So there's some, I think it goes around to Druid Hill and Parker Street. But I wanted to give you an idea of post-Reconstruction Baltimore. So when we talk about Reconstruction, we're talking about the time period between 1865 and 1877, where the goal was to redress the inequities of slavery. Now, Maryland was never seceded from the Union, so it didn't really benefit from the federal Reconstruction like some of the southern states did. However, there were still pockets of racism in Maryland because some of the white citizens still had southern sympathies. Baltimore, however, had made some progress toward racial justice. At this time, they had abolished discriminatory state policies known as the Black Laws. However, the only thing with Baltimore is that they had a very unjust criminal justice system which unfairly incarcerated African Americans at a staggering rate. And it was one of these victims of the system who would become a client for Johnson in one of his most prominent cases. So I got to tell you about 3 of Cummings and Johnson's most impressive cases. I really had a good time researching this. So the first case was the Sampson case, and this occurred in August of 1889. So Sampson was a young black man, he was a clerk, and he worked at a coal dealership. And in August of 1889, he was accused of rape by a young white woman named Mary Wren. And so at his arraignment, he pleaded guilty, and he hired Charles Johnson to represent him. Now remember, at this time, Johnson had only been practicing law for like 2 months. But at that time, he had actually stacked up an impressive 15-win victory. So he was impressive. So Sampson's trial was oversaw by the comic Judge Duffy. And it was actually a packed courtroom because everyone, both black and white citizens, wanted to see Johnson in action. This was actually going to be the first time a black lawyer pleaded a criminal case in Maryland for which the sentence was death. And so that's why everyone was kind of caught up as horrible. So after the state gave the opening arguments, it was time for Johnson to give his opening arguments. And the room was silent. And when I was doing my research, it was interesting how the newspaper articles described it. They described it as a masterly display of English language. And so Johnson eloquently portrayed the facts of the case and indicated to the jury what he intended to prove. His presentation was so impressive that it actually forced the judge to put his pen down and take off his glasses and lean forward to soak in every word he was talking about. So after completing his argument, Mary Wren got up to give her account about what happened at the house of Sampson. And without hesitation, Johnson subjugated her to a 2-hour cross-examination that completely blew open her story and unraveled it. And after that testimony came the examination of other witnesses before the all-white jury went to deliberate. And they actually returned a verdict of not guilty without even stepping out of the jury box. So that was impressive. I'm telling you, I really enjoyed it. And so Johnson's friends kind of came in the courtroom and hailed him as a hero and took him out. So that was interesting. Now, normally Johnson would actually work with other attorneys. I think a few weeks after the Sampson case, he actually helped the state in prosecuting 4 white gentlemen who were accused of raping a black woman. But more often than not, he actually worked with Cummings. And so one of their cases together was at Baltimore County. And this is a picture of the Baltimore County Courthouse. And they were representing a black man who had been arrested for assaulting a white woman. And this is actually the first time that black lawyers represented stood in front of a Baltimore County courthouse. So it was a pretty big deal. And during this argument, they presented an alibi argument. In other words, they were able to argue that their client was somewhere else at the time. And because of this, despite being an all-white jury, they were able to get a not guilty verdict for their client. So I thought that was really interesting. In addition to criminal work, Johnson and Cummings also were engaged in several litigations representing citizens who were fighting against segregated laws at the time. Baltimore was mostly integrated, but there were still pockets of segregated facilities in which blacks were excluded from services. In fact, in 1890, prejudice against black citizens actually increased, and many blacks were turned away from hotels and restaurants and theaters. Theaters, if they sold you a ticket at all, black citizens had to sit on the upper rows. In December of 1890, 2 black citizens actually hired Cummings and Johnson, and they sued a theater and a museum respectively. And they sued, and in the lawsuit, they wanted to be awarded $5,000 because they refused services. I couldn't find the results of this lawsuit, what happened, but it's speculated that they settled out of court for a sum of $50. And all of this sounds paltry. I want you to remember that even though they settled, this actually represented a change in the manner in which African Americans, use lawsuits to challenge private discrimination. So rather than simply demanding the end of segregated practices, their lawsuits were the first attempts by black people to seek monetary damages against institutions for civil rights violations. So this is a really big deal. So, no discussion about famous African lawyers would be complete without Ashby Hawkins. So Ashby Hawkins and another student named James Dozer attended the University of Baltimore in 1889. And again, this is the same year that Cummings and Johnson graduated. Unfortunately, at this time, a lot of the students and teachers were tired of immigration, and they actually compelled and petitioned the school to get rid of them. And the school, by the public pressure, unfortunately expelled Hawkins and Dozer from the school. Hawkins would later attend Howard Law School in 1892, would take some years off to teach, and then he would become a lawyer in 1897. And he would actually open up his own law firm. And interestingly enough, one of his first clients was a student named Robert Clark, who himself was kicked out of an institute of higher learning. So this gentleman, this is Dr. Cardale. He was actually a prominent Baltimore city council person. And at the time, city council members were allowed to appoint students to join the prestigious Maryland Institute of Design. And so he nominated Robert Clark to join in 1896. However, at this time, the school had gotten tired of admitting black people, and due to public demand, they actually passed a bylaw that prevented Robert Clark from enrolling, unfortunately. So Robert Clark would hire Ashby Hawkins to file a petition in October of 1897 for a writ of mandamus with the Supreme Court of Baltimore. And basically, this is an order asking the court to order the institute to admit him. And so, in front of the, when Ashby Hawkins argued in front of the court, he had 2 arguments. So his first argument was that The bylaw the school created was a violation of the contractual agreement between the city and the institute to allow students in regardless of color. The second argument was that the bylaw was against the Equal Protection Clause of the Constitution. Now, in response, the school filed a response saying, look, the reason why we had to pass this bylaw is because we were suffering under public pressure by admitting all these black people in, and we weren't able to find quality white people, so this was pretty much why we had to do this pass this bylaw. And unfortunately, the Superior Court sided with the institute. And the court said that private corporations are not subject to the 14th Amendment Equal Protection Clause. That only prevents state action, not private action. And so because of this, Hawkins had to appeal to the Maryland Court of Appeals, who unfortunately agreed with the lower court and indicated that the school hadn't really violated the contractual obligations because as a private institution, they could pretty much hire and bring in whoever they wanted. So even though Hawkins was unsuccessful in this, he would go on to fight some of the other turn-of-the-century anti-suffrage laws that we're going to talk about in 1 minute. But before we get to Hawkins, I want to come back to Cummings and talk about him. So he became the first African-American council member in 1891. And so he was able to use his, or leverage his position on the council to pass different laws. Thank you so much. I appreciate it. I think I'm sweating worse than sitting in church. So this is him on the council. You can see him. That's him. That's all the other council members. So he passed a series of education proposals. One included a citywide kindergarten course. He also hired a black director of sewing, and he also passed an ordinance establishing a night school at the Color Polytech Institute. So this is a training school for black teens that teach them trades. And so this goes to show you that sometimes you can advocate for the rights of African Americans outside of the courtroom. And he used his opportunity as a politician to advocate for black students. So I want to actually finish our talk by looking at some of the challenges that African American lawyers faced at the turn of the century regarding anti-suffrage legislation and ordinances with racial discrimination housing. And for those who don't know, anti-suffrage means laws that prevent you from voting or put barriers, unreasonable barriers that prevent you from voting. So 1900, the Democrats were at the time with the bad party. Sorry for being close to The Democrats, they pretty much took over Maryland. They took over the State House, they took over the governorship, and the rallying cry was, this is a white man's city. And immediately after taking over, they began to pass a slew of segregation laws aimed at black Marylanders, mostly involving voting and public transportation. So some of the laws I just kind of put on here was a law requiring knowledge and the art of reading in order to select a candidate to vote for it. So this was proposed but never passed. They also proposed several ballot box initiatives, one including replacing party emblems with written party designations to make it more confusing to figure out which party you're voting for. Another one provided for easy invalidation of ballots if you don't use the right mark. So even if you vote for someone, if you don't use what was called the stipulated cross mark, your vote could be thrown out. So luckily, all these measures failed. But then they came up with their most insidious plan yet. Poe Amendment of 1904. Ooh boy. So this is named after the dean of the university, Poe. I think he was related to Edgar Allan Poe in some way. But he was actually the dean of the University of Maryland at the time that Ashby Hawkins was there. He was instrumental in kicking him out, unfortunately. So the Poe Amendment had two provisions, and I'm going to read both of them. One was the grandfather clause. Let me know if something sounds bad. So the grandfather clause provided that all persons eligible to vote on or prior to the first day of January 1869, and male descendants of each person who would be 21 years of age by 1906, henceforth would be able to vote. So what's the problem with that? It could be the fact that black voters weren't able to vote until 1870 with the 15th Amendment. So this meant that they would have to qualify under the second provision called the Understanding Clause. And the Understanding Clause basically said that it stipulated that persons unable to qualify under the grandfather clause would be able to vote if they could offer a reasonable explanation of any section of the Maryland Constitution. So that meant that voter registrants could just stand in polls and ask you to explain the Maryland Constitution, and if you couldn't provide what they thought was a reasonable explanation, you couldn't vote. So the true purpose of this amendment was obviously to disqualify thousands of black voters from voting. Now, it's important to keep in mind that this was passed by the state legislature, but because it took the form of a proposed amendment to the state constitution, it first had to be voted for in the November 1905 election. So as you can imagine, black leaders, including many black attorneys, converged to fight against some of this Jim Crow legislation concerning both public transportation and voting rights. A small cadre of black lawyers who were recently admitted to the bar included Cornelius Fitzgerald and William Fitzgerald. And Cornelius Fitzgerald, I believe that's him right there. And I'll tell you about some of the other leaders in a minute. But black leaders initially banded together to fight a group of laws called the streetcar laws. And these were laws that segregated steamships and trains and whatnot in 1902. And then when the Poe Amendment was proposed by the Democratic Party, they kind of reconformed in what's called the Suffrage League of Maryland, and that was to fight against the Poe Amendment. And so this was comprised of esteemed black attorneys, including Ashby Hawkins and Harry Cummings. I don't know everyone in this picture. This is Harry Cummings, this is Ashby Hawkins, and this is actually Reverend Johnson. So this picture was, I think, in 1900, so he was still around. He was still around for the fight, so that's good. Okay, so some of the strategies they used in 1905 included holding rallies, distributing pamphlets, raising donations, and teaching illiterate blacks on voting procedures and some of the rules of voting. And they also spoke at large congregations. In fact, I found one in September 1905, a few months before the vote for the Poe Amendment, in which Cummings spoke at the annual Men's Day celebration at the Methodist Episcopal Church. And basically, he's speaking to the congregation of black citizens about the dangers of the anti-suffrage movement and making sure they're registered to vote and fighting against this. So, the defeat of the Poe Act. So, interestingly enough, voter turnout was actually low. It was only 63% of registered voters. And what was more surprising was that there was a greater amount of white voters compared to the 80% of African Americans in Baltimore who were registered to vote at the time. Still, the attempts of the anti-suffrage league were victorious. 70,000 individuals voted for the amendment, 104 voted against the amendment, so the amendment failed. Of course, the Democratic Party wasn't done, so they tried to pass other laws, including the 1908 Stross Act and the 1910 Diggs Amendment. And these were just other attempts to disenfranchise African Americans, and fortunately they failed in the same manner as the Poe Act. However, the greatest threat was on the horizon because rather than seeking to disenfranchise African Americans, the segregation movement now wanted to look at segregating African Americans based on housing, which was the next fight that came. So in December of 1910, Baltimore passed a residential segregation ordinance that basically prevented black and white Baltimoreans from moving on blocks in which the majority of residents were of the same race. Meaning that if you were a black individual, you could not move on a block in which the majority of the residents were white. And Baltimore has the distinction of being the first city in America to pass such an ordinance. So let that sink in Baltimore. So the attack against this bill came on two fronts. So Cummings was still in the city council. He was championing against the bill and the various versions. But the real fight against the bill came in the form of challenges in the courts. And so Ashby Hawkins would actually he would actually use a test case to fight the bill in court. And he actually won. In February 1911, he was able to convince a judge to declare the ordinance invalid based on unreasonable classifications. So basically, he won on the technicality. So what did the city council do? Did they just give up? No, they passed various forms of the ordinance. So they came out with a 1910 form, a 1911 version, and then finally a 1913 version that was really the final iteration that was deemed legally sufficient. So again, Hawkins challenged it by initiating a test case where he had a black gentleman remove one white block so he could, violate the law and use it as a test case. And so he argued in front of the criminal court, and the judge actually declared the law, the ordinance invalid because of arcane language used in the ordinance. So the city wasn't done yet. They actually appealed to the Maryland Court of Appeals. And when they did that, the argument then centered on whether the ordinance was a reasonable use of the state's police power. And so every state has what's called state police powers. And these are powers that every state has to regulate the health, safety, and welfare of the citizens. And so the court decided that the separation of races for the purpose of preserving the peace was a reasonable use of this police powers for the ordinance. And so the ordinance kind of maintained. So of course you can imagine Hawkins was at his wit's end. And he wanted to immediately initiate another test case. He actually got the NAACP involved. He found another test plaintiff to get involved. And he filed a petition with the Maryland Court of Appeals again. However, the court delayed the decision in this instance, opting to wait, because at the same time all this was occurring, there was another case in the U.S. Supreme Court, Buchanan v. Worley, and this involved a similar statute from Kentucky. And so the court wanted to wait to see what the U.S. Supreme Court would say in this instance. And so in the case of Buchanan v. Worley, the U.S. Supreme Court said that laws in which residents were segregated based on race were unconstitutional infringements on the right to property. So what did this do? Because this was a U.S. Supreme Court case, this invalidated all laws of that sort, including the one in Kentucky and the one in Baltimore, ending the odious practice of racial segregation at the housing level. Now, let me get there again, sorry. So this ends the second generation of lawyers. So Ashby Hawkins would go on to practice law for many decades. He would actually run for the U.S. Senate in 1920, I believe, and then he would eventually, unfortunately, pass in 1941 from heart disease. Cummings, unfortunately, would pass on September 6, 1917, and the decision for Buchanan v. Worley occurred in November, so by that measure, he actually didn't live to see the decision in the first place. But the city did honor him by flying the flags at half-mast, and there was an interesting editorial of him written in the Baltimore Sun. So that doesn't end our discussion, though, because I want to resurrect the name with your permission. Mr. Draper. So in the fall of 2022, there was an initiative by Judge Browning, the same one who wrote the law review article, to right the wrong and give him the recognition that he deserved. And so I actually worked with Judge Browning and Professor Anderson at University of Baltimore Law School, and we actually put together a symposium in February 2023 that kind of went over Draper's life and some of the other black attorneys at the time. Then in March of 2023, we actually filed a petition to posthumously admit to the Maryland Bar Draper, and they actually planned to act on it. And we contacted different bar associations, the Lyon University Bar Association, the Alliance of Black Women Attorneys, to write letters in support of the posthumous admission of Mr. Draper. And wouldn't you know it? This is a picture. So Mr. Draper got his due what he deserved. This is an historic day. Mr. Draper became the first black attorney to practice law in Maryland. So that's me, Professor Anderson. This is the court clerk of the Supreme Court. I can't remember his name. And this is Judge Browning, the one who wrote the law review article and kind of initiated this. So it was an interesting ceremony. I actually got to read the oath of office for Draper, the oath that he would have taken as an attorney, and also the next class of lawyers who were going to read the oath. They actually set an empty chair in memory of Draper, as if he was there. And even though Draper died without any heirs, they were able to contact Dartmouth College and bring some of the alum to come up and attend on his behalf. So I thought that was a really great occasion, and it was attended by the governor and dignitaries around the state. So it was really remarkable, and it really goes to show you that justice delayed is not always justice denied. And I want to end the presentation by just giving you some statistics of black lawyers. Despite thousands of black lawyers, we still hold a very narrow margin in terms of representation. 13% of the population are African Americans, but only 4.5, and I think that number might actually be lower. Only 4.5 of lawyers in America are African American, so we have a lot of work to do in terms of increasing that number. This is interesting that Maryland actually has the second highest concentration of lawyers among states, and I figured that's purely because we're so close to Washington, D.C. And so with that, that's in my presentation.
I got two questions for you.
Please.
First of all, why did Mr. Sampson plead guilty before his trial? And the other one is, when did we have the first black judge?
So
repeat the question?
Oh, sure. So
We're recording this, so we'll repeat the questions up here so it can be recorded.
Right. So the question was, why did Mr. Sampson plead guilty, and when did we have the first black judge? So I actually misspoke. He pleaded not guilty. So I apologize for that. So thank you for that.
Okay.
And then we actually had the first. So we have a museum of Baltimore legal history. It's down at the courthouse.
Oh.
The first black judge, I can't remember his name to save my life, but I don't think that actually occurred until the 1940s or 50s. If anyone knows any differently, let me know. But I believe our first black judge in Maryland was in the 1940s or 50s, around that time. Thank you. Yeah, took that long. Any other questions? Or, Dr. Jones?
Thank you for your presentation. It was very insightful. Can you talk about the effort to disenfranchise black men in that first quarter? Where were the women? Because I know there were women involved with helping to push back the disfranchisement. Did you come across any of that in your research?
I actually did. So the question was about the disfranchisement of African American attorneys and the help of women. And I actually came across the first woman attorney, and I can't think of her name to save my life, but I believe it occurred in 1900, I believe. But women did play an integral role in the disenfranchised movement, especially involving the suffrage league. Again, women didn't get the right to vote until 1920, but I did come across several individuals in my research during that period that joined the suffrage league and then joined the Niagara movement to kind of help lead the charge against anti-suffrage, because they couldn't vote any more than African American men. So, but thank you. Oh yes.
Thank you for a brilliant presentation. So you mentioned a couple of names that I really love. Ashby Hawkins, who wrote the amicus brief in the property cases. But did you find any intel on George W.F. McMecken?
Yes, actually, George McMecken was a law partner of Ashby Hawkins, and he was instrumental in the fight against the segregated ordinance. And I believe he may have continued working with Ashby Hawkins for the 1920s and 30s. So yes, absolutely yes.
I mean, so the second part of the question is, often, so I wrote about that ordinance too, Baltimore City Ordinance 610, 611, 612. And it was written 3 or 4 different times. The third time it was rewritten by a partner at a law firm, Michael Marbury, the Marbury guy. And so that whole Poe legacy, that whole, is a democratic push. One of the things that you don't talk about though is, again, this is probably not the time and the space, but that kind of like the violence that was erupted around these cases. And so, the courts often looked at these measures as literally settling the ill will between the races.
Right.
Did you find any intel? Was that mentioned or?
So the question was, did I find records of violence that occurred during this time? There was violence, but I guess that wasn't my focus. We're focusing more on the laws and the impacts they had on society. So I imagine that, there were certainly supporters of the Poe Amendment at the time, and so there were clashes between supporters and opponents of the Poe Amendment that did occur in the time leading up to the vote. So I did kind of.
The reason I asked that question is because when I was doing the Morgan lawsuit, which actually comes from the same thing, because it's not only houses, it's businesses and schools too.
Oh, okay.
This law applies to.
Right.
And so when the Morgan case goes to courts and they finish litigating it, he goes to Annapolis, and there's 3 different bills that really threaten, like they're written to reduce, literally like civic violence. And so it's not about just kind of like the transference of property. It's literally to keep the blood from out of the streets.
Right. And for the first part of his question was about a gentleman by the name of George McMecken, and he was a law partner for Ashby Hawkins and also was instrumental in fighting against that ordinance I was talking about. Yeah, thank you. Oh, yes.
I was wondering, given kind of the economic condition of the client base, were these lawyers able to make much of a living?
Oh, that's a good question. The question was, were the lawyers able to make much of a living during this time? I can't imagine. I didn't come across, how much they paid, but I can only imagine that the pay wasn't that good. Again, Johnson was taking cases 2 months out after practicing, after becoming a lawyer, and so I'm sure he was kind of hungry for cases. And I remember he became a lawyer in 1889, and the first black lawyer was 1885, so this is only 4 years after the first black lawyer. So I can only imagine, at least I'm guessing, that they probably took anyone they could. And I'm not sure if maybe monetary compensation was one of their goals so much as it was, righting the wrongs at the time that existed. It's a good question. Yes.
So I was curious, I know that you said that the African Americans not being able to join a jury was kind of the first thing that led to African Americans being able to become lawyers and admitted to the bar. But why would one necessarily be linked to the other, since they're different roles and sort of?
Right. So the question was why in terms of African Americans joining the becoming part of the jury, why was that linked to African Americans who linked to the argument that African Americans should be able to practice law? So what happened was during the Henry Wilson case, they were desperate to find cases in which the court had previously found instances of discrimination under the Equal Protection Clause. And so the right to serve as a juror was just one of several cases that they cited to in their argument that the right to practice law is the same type of infringement that the Equal Protection Clause covers as the right to serve in the jury. And I'm sure there were other cases that they cited to, but they were just using different instances in which the Equal Protection Clause said that these are rights that are protected, and now we're kind of joining together the right to practice law as a right. So, but that's a good question. Yes?
So just a quick question. You had mentioned the Baltimore Racial Segregation Ordinance, and I wanted to know what the name of the test case was. If you knew, you mentioned that there was a test case.
Yes, so let's see. I have his name here. The first test case was, give me 1 second. I actually have his name somewhere on page 28. I didn't know you could actually put notes in the PowerPoint. My wife said, why do you have paper? I'm like, oh, I'm sorry. So the first case, John Gurry. So the plaintiff in that case was John Gurry, and this was the test case for the 1913 iteration of the statute.
Thank you.
Sure. Yes.
Did Justice Marshall in the Brown case go back and bring any of these cases forward that these lawyers had brought that were defeated to gain the Brown decision favorably by the court?
Excuse me. That's an interesting question. So Brown v. Board centered on separate but equal, which came from the 1897 case. So these cases, most of these cases occurred at the local level in terms of the Court of Appeals. The Buchanan v. Worley case in 1917 that invalidated the ordinances, that would have been a different case that wouldn't have been necessarily relevant to separate but equal. So again, most of the cases that we were talking about happened at the local level with the Court of Appeals, and so I doubt that the Supreme Court and the Brown v. Board would cite the several of those cases. Now, the NAACP did use some of these cases in their early 1930 initiative to kind of overturn or argue that segregation was, they actually used separate but equal as a reason to say, hey, if you have separate facilities, you have to have equal facilities. There was actually a case in Maryland that said that in Maryland Law School, there was a gentleman, I can't think of the case, but he wasn't allowed to join the Maryland Law School, and so they argued, well, in the separate equal, there needs to be an equal school. Where is it? And they either had to build an equal school or allow him in, and of course they decided to.
Okay, to follow up, how does Plessy v. Ferguson interact with this?
Sure, so Plessy v. Ferguson, Plessy v. Ferguson, I believe it's 1896 or 97, one of those years. So in 1900, the question was how does Plessy v. Ferguson interact with this? So in 1900 and 1901, when the Democrats took over, they began passing segregated laws with public transportation. So these were called I have it in my notes here, but basically they were able to pass laws that provided for segregated accommodation in steamships and trains, and they were able to cite the Plessy v. Ferguson, the separate but equal provision from that case in support of these laws. Yes.
I was wondering about maybe Maryland's most famous, Baltimore's most famous black attorney, Thurgood Marshall.
Yes.
Just wondering, he's at least one, if not two generations after people like Hawkins and McMecken. Did he have any awareness of these predecessors? Did he ever acknowledge, did he have any sense of any awareness he had of them? And I guess also, kind of related to that, Charles Hamilton Houston, did he have any interactions with any of those people who preceded him, but not by too much?
So the question was, did Charles Hamilton Houston, who was the dean of Howard Law School and the mentor of Thurgood Marshall, and whether Thurgood Marshall had any interactions with this generation? The only one I'm aware of is Ashby Hawkins. Thurgood Marshall and Ashby Hawkins actually were instrumental in starting the Monument of the City Bar Association in 1935, which was one of the first African American bar associations. So they certainly worked together in certain respects. I believe Thurgood Marshall was in law school in the 1920s, I believe. So I'm not sure if he would have had any interaction with some of the earlier ordinances in terms of Baltimore. But he did work with Ashby Hawkins on another number of initiatives. Yes.
Quickly, I just want to say, the person who asked about how you could make a living, very frequently black and immigrant attorneys would start general businesses where, you know, it might be like an employment agency and a law firm, and that helped to lead to the laws that said a law firm can only do law. And it became unethical to do anything more. But one of the questions I have, do you have any indication why in the In re Taylor case they only made a privileges and immunities argument and apparently didn't make an equal protection argument?
You know, that's a very good question. So in my research, I think he may have, I have to go back in my research, but I think he may have alluded to the Equal Protections Clause, because the Privileges and Immunities Clause is mentioned in Article 4 of the Constitution and the 14th Amendment. And the Equal Protection Clause is also mentioned in the 14th Amendment. So he may have alluded to the Equal Protection Clause in re Taylor, but I think his main argument was the Privileges and Immunities Act of the Constitution. But again, since they're both in the 14th Amendment, he may have alluded to that, but I don't think that was the strongest argument. But who knows? It may have. He may have won if he used that.
Or maybe the court heard what it wanted to hear.
Probably right. And remember, at the time, even if he had used the Equal Protection Clause, this was 1877, so there weren't that many cases that he could have alluded to where the Equal Protection Clause would have called for different forms of discrimination being barred. So the plaintiffs in 1885 had more cases to draw on to cite why blacks should be able to practice law versus in re Taylor in 1877, where there weren't that many cases that he could have used for an equal protection argument.
Other questions?
Oh, yes.
Maryland being a border state between North and South, do you have any sense of how that might have affected the successes or failures of the lawyers that you studied? Like, for example, would lawyers in the North have like a completely different experience, and then were there even black lawyers in the Deep South during this time period? So, like, could you fit in Maryland and sort of what was going on?
Right, so the question was, Maryland being a border state, what was the context of lawyers and blacks being able to practice in Maryland and other states? So, interestingly enough, Maryland was one of the only states that actually passed a law. If you do the research with other states, even some of the southern states, there wasn't really a barrier per se that prevented African Americans from practicing law. Of course, certainly there were prejudices, and people didn't want African Americans to become lawyers, but it wasn't codified. In most states, African Americans had to read the law in terms of reading the law under another prominent attorney before they could qualify. I do know Macon Boland Allen, the first black gentleman to become a lawyer. He was in Maine, but he wasn't actually. Maine had a provision where you had to be a citizen of Maine in order to become a lawyer. He was actually a citizen of Indiana, so he couldn't become a lawyer in Maine. He actually had to take an exam. And so because he passed the exam in 1844, he was able to practice law. But he didn't stay in Maine. He actually went to Massachusetts because it was a little more favorable for African Americans. But if you're talking about Maryland as a border state, there were still a lot of southern sympathies at the time that really prevented African Americans from really branching out and practicing law. I mean, we all know that, you know, the first shots of the Civil War actually occurred in Baltimore on Pratt Street. And Baltimore was taken over by Abraham Lincoln because of that. But yeah, so but Maryland had a weird status as a border state. Not quite southern, but not quite northern. So. Thank you.